All right, first up this morning is a panel that I'm sure y'all are all excited to see. It's one on emerging management issues for large-scale production permits. Moderating this panel is John Dupnik. John is the Deputy Executive Administrator of the Office of Water Science and Conservation at the Texas Water Development Board. I hope I got that right. I'm now going to, yeah, it is a lot. I'm going to now turn it over to you, John, and please welcome our panelists to the stage.
All right, one question before we get started, Adam. That stress management talk, is that going to include a tour in the lazy river? I think it should. Yeah. Anyway, welcome everybody and good morning. Just to make sure that you're all oriented, you're about to hear a panel discussion on emerging management issues for large-scale production permits. I happen to hear that the TIPRO folks are also in the building, so if you're part of that, that's not what this is, just to make sure you're all in the right place. But it's our pleasure to kick things off this morning. Hope you've all had your coffee. Hope you all have rallied from the lazy river and the ping pong and the networking. It seems that there's a good amount of people in the crowd. You're all bright-eyed and bushy-tailed, and I think we will be able to keep you engaged because this is a very juicy topic, and if you're water wonk like I am, this is kind of caffeine. This is what I really get into because we're going to dig into this topic of large-scale production permits, particularly for exports, and it covers the gamut of all the interesting water policy questions in my mind. So I'd be remiss if I didn't acknowledge that the inspiration for this topic was an article published in the Texas Water Journal just a few months ago. 3 of the authors are on the panel here, but I really encourage you to take a deep dive into that article. It explores all the aspects of these types of permits with a focus, of course, on the Vista Ridge permit and how Post Oak Savannah Groundwater Conservation District manages that project. So it's sort of the inspiration. But we're going to use that to really dig into some of these questions. So again, my name is John Dupnik. I'm with the Texas Water Development Board. It's my pleasure to be the moderator of this panel. So let me start by introducing my esteemed august panelists, starting with Mr. Steve Young. With INTERA, hydrogeologist, consultant. He's been in the water space for a long time. He was the lead author on the paper, and he will be representing the technical and the science aspects of these issues. Then we've got Mr. Carlos Rubinstein, with you all know very well, requires no introduction. Spent some time at TCQ as commissioner, then of course was chairman of my agency, the Texas Water Development Board, and now is a consultant with RSA H2O. And has the ear of many of the policymakers, I would say. So Carlos still stays very busy and is engaged in all these questions. Then, of course, we also have Ms. Laura Martin, and I call Laura the practitioner of groundwater management, because all the attorneys and the policymakers can wax poetically about how we do this, but the GMs of the districts, you have to do this work. And so Laura will be representing the perspective of the GCDs and those practitioners of groundwater management. So please join me in welcoming my panel. Oh, sorry, Russ, I didn't mean to leave you out. You said you wanted to sit on the end, and then you got off the radar, and the TIPRO thing got me distracted. How can I forget Russ Johnson? Russ is the legal brain on the panel, and we got to have one of those. And I try not to ignore the attorneys, but it's just habit, I guess, Russ. Sorry about that. But Russ, of course, with McGinnis Lochridge, he's been in the water world for many, many years and has been part of one of the pivotal groundwater cases that have really shaped the way we think about legally groundwater law in Texas. So my apologies, Russ, I got a bit ahead of myself. But one more round of applause for including Russ. Okay, so I'm going to set the stage, provide a little bit of background. You all are very, very familiar with some of the eye-popping projections that have come out of the state water plan. Of course, we're projected to grow as a state from 30 million people to about 50 million people by 2070. And it comes as no surprise that that's the largest driver of the demand for water. The municipal sector is associated with that population growth. Also comes as no surprise that that population growth is going to be focused on the urban centers, particularly on the I-35 corridor from from Dallas all the way down to down here in the San Antonio area. We're going to be focused on the Creasy-Wilcox project, and that particular aquifer is a target for some of that growth, with a focus being on the Georgetown to down here in the San Antonio area. It comes as no surprise that the Creasy-Wilcox let's go straight to that. Creasy-Wilcox is a target for being able to accommodate this growth. We know that surface water projects are hard to come by. Reservoirs take a long time to build. Interbasin transfers are a factor. So folks are looking to groundwater to be the future source to accommodate this growing demand. Creasy-Wilcox is uniquely positioned to be parallel to the I-35 corridor, and that's no accident. I-35 was on this side of the escarpment for a reason, but the aquifer also is run parallel to the escarpment. What you see on the map here is GMA 12 with the outcrop and the subcrop of the aquifer. This is really where a lot of the focus is, but I do not want to leave out GMA 13 just to the south in Flores District, which is Gonzales County just to the south there. But again, it's directly parallel and adjacent to these growing areas. It's also very prolific. There's a lot of water in storage, a lot of water under pressure, so it stands to reason that a lot of prospective projects are coming from this area. The Vista Ridge project really is kind of the test case for all of this. If you all are not familiar, Vista Ridge is a project that was permitted by the Post Oak Savannah Groundwater Conservation District in Burleson County. It's permitted for just north of 50,000 acre feet for transfer for production and export via 142-mile pipeline from Burleson County to down here to San Antonio. So it's taught us a lot. We've learned a lot from that project. It was the first one out of the gates, so it's really been kind of the source of many of these questions. But it's not the only one. According to the paper, there's about 4 other projects within GMA 12 for collectively about 110,000 acre feet of production and export. And also, Laura's district has some permits that are on the books, and then I understand there's some prospective projects down in Victoria County as well. So lots of demand on this system. So many have opined that the reality of our situation in Texas is to be able to accommodate this prospective growth, we have to come to terms with the fact that we have to move water from where it is to where it isn't, that's a practical reality. However, I've also heard a different vision from some of our state leadership, different version of it, including Chairman Perry yesterday. He said that his vision of the state is to invest in new water supplies to accommodate municipal demand. So much of that water from rural Texas can stay in rural Texas and be able to continue to support agriculture. So it's kind of interesting, different perspectives. But the real life situation today is that the water, the projects that are coming out of the gates are coming largely from these, especially in this area, from this part of the world. So we're going to take a deep dive into this topic. We're going to focus on permit allocation and the fair share doctrine. And Russ is going to take us to school on some of those legal principles and what all that means and what it means for groundwater management. Then we're also going to look at when a permit application comes in the door, how should districts be thinking about the prospective impacts on the aquifer and on wells? What are the unreasonable impacts? Let me go back to my outline here just so you all can follow along. There it is. Then we're going to shift over into looking at once the permit's issued, the wells are in the ground, water's being pumped, water's being moved, what are the district's options for managing impacts after production has begun? Curtailments, mitigation, these kind of things. And then finally, I love to finish with my benevolent dictator question. If you were king or queen for the day, what would you do to really address some of these key challenges? And that's always, if y'all see my panels, I finish that way every time. That's where the good stuff comes. Okay, so we're going to get into it. And Russ, we're going to start with you. So we're going to talk about fair share doctrine, permit allocations. Much of this concept, is my understanding of it, comes from oil and gas common law. It's been applied, at least in reference to how groundwater is managed in Texas. So could you start off by just kind of giving us a one-on-one on what is the fair share doctrine, and really what are the practical applications for districts and how they look at allocating permits?
Thank you. Well, let me start by saying I have to introduce my granddaughter who's in the audience, Anna Hikes. You know you've been around a long time when your granddaughter is attending a conference that you're speaking at. She's a junior. I'm not sure. I'm not going to make her stand up. Bless her heart. She'll be a. Very proud to have her here. Makes me nervous. I've never spoken in front of my granddaughter before. So let me give you just kind of a brief background so that we understand, what the fair share doctrine means in the context of groundwater regulation. As you know, groundwater regulation really became a thing in the 1990s with the passage of Senate Bill 1, ultimately Senate Bill 2. The bottom line of regulation of groundwater was the power to limit production. The big difference in the fair share doctrine from oil and gas versus groundwater is that in groundwater, there's a recognition that historic investment has been made by landowners in the right to produce groundwater under the rule of capture, and that historic use had to be recognized with the overlay of regulation through groundwater conservation districts. But what we do know is that under the rule of capture and the law that has emanated from that, groundwater is a property right that's vested, even though it's undefined until it's exercised. But it is a property right that is subject to protection by the constitutional prohibition against a taking of that right. So in regulation of groundwater, there has to be a recognition of that property right and a recognition of the right of a non-user to exercise that right in the future. So what does the fair share doctrine really mean? As a practical matter, what it means, I think, is that in the context of that regulation, there has to be acknowledgement, if you will, that groundwater regulation has to recognize this right to the fair share. So what is the fair share doctrine? Bottom line is it recognizes the right of a non-user to exercise that right with their right to use their fair share of that resource. So what is the what is the fair share of the groundwater right in the context of historic use, et cetera? So what's the practical application for the groundwater conservation districts? The bottom line is that you can't say no to a non-user who applies for a groundwater permit. The outline that was provided by John said, what does this mean in terms of a mandate to groundwater conservation districts? Well, the bottom line is that groundwater conservation districts have to recognize the right of a non-user to produce that water in the future. So that kind of summarizes the bottom line of the fair share doctrine. I'll turn it over at that point.
Okay, y'all heard that. We're going to circle back to this statement. It came up in our coordination call, but Russ said that a district cannot say no. So I want to circle back to that. Well, that'll be just be a little teaser for later, but I really want to dig into that concept as well. So Carlos, I want to turn to you. So with this overlay of groundwater being a private property right with, and let me advance the slide one more time here, and this, this overlay of this framework of fair share and providing equal opportunity to access groundwater by the landowners. We also have this overlay of this balancing test that the districts have to strike. And it's invoked in a couple of places, and I've got them up on the slide here. And I'm not an attorney, so I redacted them with my brain, so don't hold it against anybody, especially myself. But I captured the key pieces, I think, and that it's this notion that the districts have to strike this balance between conservation and development. It's in the purpose statement. It's also one of the key goals of joint planning to set a DFC, provides balance between the highest practicable level of groundwater production and conservation. So how do districts achieve this balance? What are the implications for state water planning, and how do they really need to think about this in terms of equitable allocation of groundwater?
Well, it really depends. First, I think when you're trying to balance these issues, we need to recognize that the scale itself has been jigged with. You've already, yeah, you have. We value much more, because we don't want to get sued for a takings claim, the right to produce. So that private property right that Russ was talking about tips the scale in that favor. When we want to try to balance about how is her right to produce compared to my right to conserve, the state water plan values her right to produce to meet the needs somewhere else higher than my right to keep the water in place. So the scale has been tipped. So we want to strive for balance, but in practice and how we have carried on state water planning makes it that much more difficult. We can talk about how districts try to allocate water on so many acre feet per acre, but that implies obviously the right of everyone to be able to develop at that rate per acre. Not all districts do that, but that is a way of doing it. We have the ability in some districts have exercised it to monetize your efforts to conserve. If you have the right, because you own the water, to produce it, and that's returning an economic benefit to you, if I want to conserve it, I'm going to be upset if you're monetizing my right to conserve it. And so incentivizing the conservation by monetizing it is another way of trying to do it as well. I think at the end of the day, we have to get to the point where the area of origin impact has to be valued as much as the area that's going to benefit or where it's going to destine, particularly when we're dealing with export permits.
Yeah, man, another thing we're going to queue up for later. Remember that basin of origin impacts piece. We're going to circle back to that later as well. So Laura, again, you're the one on the ground that has to make sense of all this. So you got, legal ruminations about what fair share doctrine is, what that means. You've got these balancing tests that you've got to be able to consider. How does all that affect the framework for permitting, and how do you guys look at it in your district?
Thank you, John. And thank you for inviting me on this panel with all of these pioneers and legends of water. I appreciate it.
No pressure.
Well, in order to look at that, the GCD has to determine, first of all, how much is available. How much water do you have in your district? And then looking at the availability of the water that's there, you've got to consider all of the legal parameters and the precedents and the statute requirements that enable districts to place those correlative rights in place to manage the area. And then moving to a reasonable amount based on the availability. So looking at what would be reasonable that doesn't interfere with your neighbors and the case law that's ever changing and evolving, then you'll be able to see the laws that are tested and modified and adjusted to evolve with the changing times. And so it's a lot to consider when you're managing the water availability and looking at all of the parameters that you have to consider. So don't forget all of those details that come together and moving parts that are required in order to sorry.
Yeah, so you talked about one thing that you mentioned that I want to dig into a little bit. Is you talked about the importance of really understanding what's available.
Yes.
And having a good accounting of how much water you've got. That's kind of a good segue to this question, which is the second part of the question. Statute, and I've got it here up on the slide, 36.11332 gives instructions to districts on the types of things that are considered. There's permitting factors, but there's also this section under permits based on modeled available groundwater, although I don't know that MAG is really as influential as it used to be. But I picked out 3 things that it says are to be considered that relate to this assessment of what's available. But it says that districts should be considering MAG, the availability, should be considering what's under permit, and also how much is actually being pumped. And those are going to be very different numbers. Those are 3 very different things. But can you talk about a little bit about in your district how you consider these factors?
Absolutely.
And
Thanks for
allocating
bringing me
permits?
back around there.
Yeah, sure. Gotcha.
So in Chapter 36, 1132, those 5 items that are considered are listed, and we do use the MAG as a tool to help us manage the water that's available. We have to look at the number of issued permits. So what is your total issued permit amount? How much of those permits are being produced? Is it the full amount? Is it only a partial amount? Does the producer intend to ramp those production amounts up over time? What is their intended use long-term? And then also looking at the future of exempt use, that's a consideration. How the population will be changing and the exempt use will change over time. So once again, many factors to consider in your calculations, and also going back to the availability and remembering how much water is available in your area.
Yeah, so I'm going to go off script here and just kind of follow up with a question. You can all jump in here. But I have observed that the MAG seems to have less of an influence over permitting, total permitting at least, than perhaps was contemplated here. I don't know what the intention was. But there are many districts that are permitted well beyond the MAG. And should the MAG be more of a upper limit, or how should the MAG be factored into some of these permit decisions? Nobody? Anybody?
Well, let me say this. That's a goal. It's not a limit.
Yeah.
The bottom line is that it has to be recognized as a planning goal. It can't be used as a mechanism to deny a future permit, in my opinion. So as a practical matter, it's it's for management purposes, but not for permitting purposes.
Right. So the DFC, goal or limit? What do y'all think? Or do you want to,
Yeah,
thoughts
well,
on the MAG, Carlos?
It's MAG, it's DFC, it's what we've been talking about. I think it's also sustainability as well. All of it deals with it. I go back to the comment that Senator Perry made yesterday. For those of you that were here, the one comment, all of his comments are important, but the one that struck me the most is, if we don't get this right, then I'm going to have to start looking for land for my grandchildren in another state. Doesn't matter what you're using. We need to realize that we're not working with an infinite source of water. So there is no cap. I'm with Russ on that. DFCs are not a cap, MAG is not a cap. It's a policy statement. It's a goal. But the reality is, whatever we're using, we're not using it in a way that makes the resource sustainable. The state water plan identifies that our existing sources of water are declining by some 18%. Well, that in itself tells you we're not doing a really good job of living within our means. If we had a system that is capped, the Edwards, or if you want to go surface water, the Rio Grande, it adjusts for the water availability and everybody understands what right to water they will have. We don't have that everywhere else.
Yeah, what I'm hearing is there's not a really firm cap or nothing you can really point to. And man, when you do set a cap, there's a lot of pressure on getting that right, to your point, Laura.
Yes, I also want to add, though, that the MAG and the DFCs are still vitally important to groundwater districts because it does give us that guideline, and it does provide us with some sort of guidance that will allow us to say, put the brakes on a little bit for those that want to continue to pump and to take water from an area or to utilize the resource. So we can use those as tools to say, let's slow down a little bit and look at the science to support if this is even availability or if it is sustainable.
Yeah, so let's, we could stay on that topic all day, but we're going to move on. And I don't want Steve to feel left out. You've been kind of quiet over there, Steve, but we're gonna shift over into consideration of unreasonable impacts. And I've kind of qualified this as what kind of thought process goes into considering an application before the pumping begins? When a permit application comes through the door, lands on the GM's desk with a thud, they have to do something with it. They have to actually review this information and recommend a decision to their board. And one of the key factors that I think is very interesting in that that permit decision is this concept. I'm calling it unreasonable impacts. It's not quite worded like that, but in statute 36.113D, says that for permits for wells and permit amendments, the district shall consider whether proposed use of water unreasonably affects existing groundwater and surface water resources or existing permit holders. And I suspect, Russ, nothing against the attorneys, but when the attorneys hear a term like unreasonable, you get giddy almost a little bit. It's something that requires some interpretation, a little bit of judgment. So this is what it says, and I know that many districts are really trying to think about what are unreasonable impacts. And Steve, I know you work with Post Oak, Savannah, and y'all have thought a lot about this, but how does a district define unreasonable impacts, and what kind of criteria go into thinking about what would qualify as an unreasonable impact?
Well, I'm going to just talk about groundwater for now. If we have time, we can go with the surface water. I think there's 5 factors that I bring to attention to board members. The first is, it's in Chapter 36, is subsidence. The next is degradation of water quality. The third factor would be a sense of fair share doctrine. Fourth factor would be the cost of installing a well and operating it. And the fifth would be if there's any type of well assistance or mitigation program offered by the district or by the permittee. And the key thing to realize, these are all case specific. You really can't, I think, draw lines in the sand. Subsidence, we would be looking at the integrity of any pipelines or buildings. If it threatens their structural integrity, if it threatens drainage patterns, if it's going to affect intended use of the land. For water quality, you're looking if it's going to cause any type of intrusion of water from a surface water body or an adjacent aquifer to degrade water quality. And the other two, the fair share and cost of wells, are kind of combined together and separated. If you were in the unconfined or unsaturated, unconfined zone, where the water level is below the top of the aquifer, if you pump it, it starts to desaturate. What we try to realize that if you have a really shallow well, like a hand-dug well, if you were to pump it and to make that well somewhat unusable, they still have access to drill a well in that same aquifer, same water quality. That would initially not be considered unreasonable impact. And it gets a little more more confusing when you get into the confined section. And this is where the Vista Ridge project comes to play. These wells are very deep. They had 2 aquifers they were affecting. One was the Carrizo, one was Simsboro. Carrizo wells are 1,000 feet deep. That means the screen and the well is 1,000 feet deep. They had roughly 800 feet ahead above, a water column above the top of the aquifer. Simsboro wells were over 2,000 feet deep. They would have over 2,000 feet of water pressure above it. So when you're looking at unreasonable impacts, you realize even with these huge drawdowns, you're still having access to water. The question is at what point does that drop in this water pressure in the column determine where you reach this unreasonable impact point of view? And that, as you drop the water pressure down, to a certain point that's doable. But then you reach a point where you have to start maybe changing the size of the pump. You have additional cost of pumping. You might even have to enlarge the well. And there's that site-specific properties you have to take into account of how you decide what that is. I would say, like in Vista Ridge cases, 100 feet out of over 1,000 feet of head wasn't sufficient. But if you drop it all the way down to the bottom, you're going to have to put probably a new well in, and that's going to affect someone's ability to attract water. Pump water. So we came up with some rules that that medium that comes out to be a decision by the board, but it lies in that big range. Then of course the well assistance program, if they're offering to help give those persons the ability and opportunity to generate the pump water after they've been affected is a big factor, as also the mitigation program or well assistance program by the district.
Yeah, so what I have here on the slide, and I'm realizing now I did not get permission from the authors to use any of this material. Hopefully that's okay. This is a clip from that particular article. It shows some of the drawdown associated with pumping. I believe this is from the CREZO. There's another drawdown map for the Simsboro as well, and I think correct me if I'm wrong, Steve, some of the drawdown around this pumping center is between around 300 to 400 feet, I guess is what you guys have measured so far, and it's mapped here. And that also included one more. This might be a little fuzzy, but this, Steve, kind of speaks to where those water levels are relative to the top of the aquifer and the confined nature of the aquifer, and that there's still quite a bit of water above the formation in some of these wells. But so, Laura, I want to ask you a similar question about unreasonable impacts and how a district looks at this. But when you get an application, what can you do to sort of anticipate those unreasonable impacts? And are there permitting strategies? Are there permitting tools, terms and conditions that you can do to anticipate some of those things?
Sure, thank you. So before the permit even hits the desk, I would say that Chapter 36 has specific instructions on how to consider a permit application. So if those aren't written into your rules already, write them in. Include those as part of your rules. Lean into your hydrogeologist and your modeler. Become friends with them. Find somebody that you're going to work with and trust and who knows the data. So really utilize them as a component for your consultant piece. So when the permit is brought in and it's there at your desk, where do you start? What do you do? Start your checklist, look at your rules, follow Chapter 36, make sure all the components are there, then issue it to your consultant for a review scientifically, whether it be in-house or out-house. So then the models will show, if the DFCs are being met, if you're within your MAG, so if you're within your guidelines, the goals that you want to meet. And then having an extensive monitoring network is the next tool that you have to have. If you don't have good monitoring wells and a good monitoring network for an extended period of time, looking at trends, please do set those in place because they're essential to be able to collect the data that you need to support whether or not your aquifer can sustain a large pumping project. And then also, a stair-step approach, which these guys didn't really agree on with me on this, but having a stair-step approach to your permit. So if a permit is issued for 15,000 acre feet, maybe the permittee doesn't get the full 15,000 right off the bat. Maybe they only get 5 for the first 5 years, and then you have time to respond and collect the data that you need within that time frame to see, are the models correct? Is it responding appropriately? Do adjustments need to be made within the permit? So that's something that our district has done, is stair-step the permit out so they get increments over time, spanning out over a course of 15 years. So that's helped our district in determining, how will the aquifer respond? Is it too much too quickly? And then we were able to adjust and modify if necessary. Let's see, what else do I have here on my notes? Stay away from those unstable areas that you know and are familiar with in your district. So if you know of the areas that may have fault lines or in the outcrop areas that are going to be most affected, encourage the permittee to move their well field away from those areas to a more stable and secure area, something that is going to support their system. And then also mitigation agreement. Including a mitigation agreement or having the permittee provide monitoring wells. That can be an addendum to the permit to include additional incentives for the permit to be approved. So that way they're taking care and they're being good stewards of their area. So not only are they providing valuable resources to monitor scientifically, but they're also helping to offset the impacts that they're going to be causing with the mitigation.
Yeah, so I'm hearing you got to throw the whole toolbox at these things. Management zones, phase permitting, mitigation agreements, monitoring triggers. You got to really get creative and kind of load it all up to really be able to plan for what you cannot anticipate sometimes. So that makes some sense. So Carlos, I want to shift over to you and ask this question about unreasonable impacts from a different perspective, a larger perspective. And you mentioned earlier that you have to be able to consider the impacts to the basin of origin. The way that language was written is it does kind of just generally describe that, the proposed use of water, considering where the proposed use of water affects groundwater resources. And that got to me thinking about, you can't judge an export permit based on the fact that it's being exported. That's clear in law. But can considerations, socioeconomic considerations, or potential impacts of that pumping to the basin of origin, can that be a factor at the level of a permitting decision, perhaps?
Well, couple of things, couple of thoughts on that. The first one is you, in passing, mentioned monitoring for the determination on unreasonable impacts. I want to elevate that. I think we can model, we can predict, we can think, we can try to blame a certain producer or producers for having caused the unreasonable impacts, but those are just projections. Monitoring to timely identify that you're getting close to maybe getting to an unreasonable impact with the ability to react to it before it actually causes the damage is where the value should be. Shameless plug to Vanessa. Aquifers are infrastructure. The water does move. If we had 3 GCDs, you're all one, and you're on the other, but we're all drawing from the same bucket, then we're all drawing from the same bucket, and all of us may be contributing to a degree to what we may consider your production to have caused an unreasonable impact. So we got to be able to get to that level of understanding of the fact that if the majority of our DFCs, because if not, Robert gets mad at me. If the majority of our DFCs are calling for continued depletion or managed depletion, then all of us have already contributed to a level of impact, and we need to address it that way. I agree with you that whether it's export or in use within district, there should be no distinction. It's really what is causing the impacts to the users themselves that needs to come to mind as well. I think Steve mentioned some of the criteria that they've put into effect. I think defining it with that clarity is very important. So those are the things I would consider.
All right, and Russ, I want to shift over to you and ask you, I want to come back to this comment that you made earlier, then came up in our coordination calls, that a district cannot say no. But on the front end, when they're going through this analysis, if they've got reasonable evidence, for example, that points to the prospect of some unreasonable impacts, could that be the basis for issuing less than permitted or an outright denial of a permit? What is there any situation where a district might be able to say no to a permit?
No.
Okay. Moderator 101, do not ask yes and no questions. I should have known better than that. Okay, please expand, Russ.
So, no. The bottom line is, and I think it's been covered by the previous speakers, but there's an opportunity. First of all, you address unreasonable impacts with the management program that you put in place in your rules. So to the extent that management program in the face of a large-scale production permit would result in unreasonable impacts, yes, there is the opportunity to adjust for that, I think, certainly through the mechanisms that were discussed earlier and in the ultimate analysis. If you decide that authorization under the what I would call the allocation rules of the district would result in unreasonable impacts, I think there's the opportunity to adjust down from that point But I would suggest that once having done that, that has to be applied in the future to all permit applications. In answer to your question, no, you can't say no, but yes, you can adjust to the circumstance with the recognition that when you do that, you have to apply that to future permit.
Okay.
There, got a panelist battle going over here. Steve, you're up. Go ahead.
I'd like to, I have a comment on Russ's no comment. One option, also responds to Laura's comment about stage. If you have a correlative right and a post oak has one where you don't have that right to pump, in this case, 2 acre-feet, but it's up to that. And if there is evidence that you may be having some unreasonable impacts or affecting a DFC, I think the option is having special condition in the permits. So, as Russ mentioned, in curtailing down, they have to have some certainty that they could, have a fighting chance to get their fair share. It's up to them to manage their resource, whether they spread their pumping out over their property, so it's not all aligned on a property boundary, or they try to change their pumping during times of drought. But I think special conditions is an important option, and to have the rules clearly articulate what a curtailment program would be, and how what type of data would be based on, over what time period it would be implemented in, how would monitoring go in. But I think that is missing, and a lot of rules of how you would actually implement that so those permittees could cope with it. So I do think the options of having special conditions to put that permittee on notice and how you're going to be monitoring for it, and to have that ability over time to get that information is an important consideration.
Yeah, Carlos?
Very quickly, though, and I don't disagree with any of the comments that have been made, but if you look at water policy as a state, and you look at the water code, we've gotten so many things right, and yes, we've gotten a few things wrong. One of the things that we've gotten wrong, and I'll give you an example on the surface water side, the junior provision, where we devalued the water, surface water moving from one basin to another. If you only apply curtailment to one permittee, you're devaluing their water. And so you need to be careful there as well. That's the only caution that I would add.
Yeah, I'll just commentary on my part. I think it's interesting for an interbasin transfer, you do this receiving area to basin of origin analysis. That's not done in groundwater. Just a thought.
Yeah, and that's why they're not happening.
Right. Okay, so we're going to shift gears here, and with a little bit of time we have left, I want to switch over to after pumping has commenced. So the permit's been issued, the wells are in the ground, infrastructure has been built, lots of money has been invested in these projects. Once these projects start to produce water, you start to see the impacts to the aquifer, and you start to see the results. Laura and Steve, Laura, let's start with you. What sort of permitting or enforcement tools do you have in place that you can utilize to address some of those real-world impacts once they start to happen?
Once those real-world impacts start to happen, we're actually in a draft rule change right now to include some curtailment provisions in our rules and update those. We're looking at our current DFCs to try and model those curtailments to fit along with those guidelines. And so we're looking at the science once again and back to the monitoring, because without the science and the monitoring, then there's not anything to support the cutbacks or the curtailments. So you have to be able to justify and say, look, this is what's happening, and this is what's going on under the ground. So this is why we need to do this. So there has to be some basis of support to follow up with that. And then also, the provision should be included in the permit that you're able to do that. So not only are they listed in your rules that you can do that, but as part of the permit provisions, include those curtailments that, hey, if there's too much going on and it's too much of an impact, we are able to say, we've got to cut you back and bring you into guideline where the aquifer is sustainable.
Yeah, so Steve, a similar question. You work with districts, particularly Post Oak Savannah, and the Vista Ridge project is our test case here. But can you talk about how that district uses some of the monitoring well network, some of the data collected to really inform how you can respond to some of these impacts or from the large-scale production?
I can comment on it. I don't think I can answer it. The district has an active program in interpreting the data every year in forecasting what should be expected. That is out for public review. The techniques which we use to do that, and they anticipate what type of impact should be. So I think having that out there initially, and we do updates to how we're tracking the DFC. So we look at both anticipation of impacted wells that would need to be with their well assistance program, also looking at forecasting when you might reach a DFC. That's, I think, is very important. We have in the process of now looking at how we might be implementing curtailment, and I think that's an important process to make sure we get feedback from the permittee on. So there's we also have a few things that help prevent it, but as we're getting close to that, I think those tools are helpful, and we have clear trigger points. With different stages, what would happen as you move along, and they would be notified well in advance, so they wouldn't be expected to curtail and reach a resolution in a couple of years, or to be a longer period than that.
Right. So Russ, we talked about loading. Deploy all the tools available on the front end. Put everything very clearly defined in the permit, including perhaps trigger points, curtailments, and we've talked quite a bit about curtailments being available to be able to respond to things once pumping begins. But is permit curtailment, pumping curtailment, is that legally, is that acceptable? Can it reach a threshold maybe that it starts to become a property rights issue maybe? I guess that is a Russ Johnson question right there. Happy to hear your thoughts.
Well, first of all, I would say the opportunity to address that exists, and doing so doesn't necessarily result in a regulatory taking. Regulatory takings are complex. It's difficult to prove a regulatory taking. You almost have to establish that you've been denied a reasonable opportunity. So for a practical, application, there is the ability to reduce a permitted right without fear of a regulatory takings claim. That's the bottom line.
Yeah, well, I'll put this question in another way. Temporary curtailments are commonly used. Edwards Aquifer, EAA, Barton Springs District has them in response to drought. But more permanent haircuts to permitted production, is that a different category? Is that still something available to districts?
No, I would say, again, if you're going to apply it uniformly, then you can apply those reductions. And recognizing that a regulatory taking almost necessarily requires a deprived right in its entirety as opposed to a portion of that right. So,
yeah. Well, Carlos, a question for you. This just kind of came to mind, but I know developers of these projects put a lot of money into them. They're looking for certainty. Does the prospect of these curtailments, even if they, that could be drastic if needed, does that affect the investment in these projects or development of these large-scale production projects?
It definitely should. Everyone's looking for regulatory certainty, not just in water, but in everything. Everybody wants to understand what are the rules of the game, and let me play by those rules, and I understand then what I'm gonna be able to accomplish or gain from my project. I think if you understand that everybody can get the same haircut, that's regulatory certainty. It means you may not have the volume that you expected, but neither does anybody else. So you're not devaluing it. So I don't think that what Ross is talking about contributes or creates that uncertainty at all. I think at the end of the day, for large-scale developers, is at what point have you curtailed it? Could you potentially curtail the project enough to where it's no longer economically feasible? Now, a word of caution. We also need to worry about when developers, users of water, want to use a different law to try to trump the good work that groundwater conservation districts are doing to try to preserve the resource for everyone. That scares me more than the regulatory uncertainty from haircuts. And I think we all know what I'm talking about.
Okay, so we've only got a few minutes left, and so I just want to save just a little bit of time to talk about, I don't know, can I say the M word, mitigation? For some reason, we've avoided that for some time, but there has been some movement here, and HB 3059 was passed to revise the statute to allow for fees to be used to, the term they use is to maintain the operability of wells. Sounds like mitigation to me. Yep. But just quickly, Laura and Steve, can you talk about your practice implementing mitigation programs? What's been effective, what works, and what have you learned?
Sure, thank you. We've had a volunteer mitigation program for over a decade now, and we've spent over $2.2 million mitigating wells in the western portion of Gonzales County. So we have extensive experience in either lowering pumps, replacing pumps, or in some cases, drilling a completely new well. And this has been effective because the producers want to continue to produce, and they're going to continue to have an impact on the area. And those that are affected locally do need to be compensated in some way, or at least made whole. And I think that that's part of the balance of the mitigation program, is that if they do impact, then they are at least making the landowner, their neighbors, complete again and not leaving them without water. So with Senate Bill 3059, I do want to touch on, it's a great new tool for people who have export permits in their district. And if you have not changed your export fee yet, go ahead and change those rules and get that money so that you can implement a mitigation program to be able to help the local users.
Same question for you, Steve. I know Post Oak has, I guess it's groundwater assistance program they call it, but has that been effective? Lessons learned, anything? What are some of the key points that make it effective, and what have you learned through implementation of that program?
I don't want to pick on Post Oak, but since you called them out, I guess I have to talk about it. They really have two parts of this. The first is they strongly encourage the large permittees to have their own mitigation program, and they've been successful at that. It's their best interest to take care, make people whole within a certain distance and influence. And the second, we had this discussion with the board in 2016. That's when they started talking about the need for some type of well assistance program. There was a lot of controversy in how that could be implemented. Gary Westbrook had lots of discussions with attorneys and other organizations of how that could be implemented. And I'd say it's been pretty much a success. They've been well over 100 Carrizo wells meted with that. They've been pretty met with success. Most of it's just lowering the wells, but a couple $1,000s is a lot of money to a lot of folks, and knowing that would be done, they gave technical assistance. It was proactive. We have a program that tells you what the next 10 years, what we think would happen. People come forth. They don't wait to the last minute where things are really dangerous for them. So they've been able to get this done in time, and I think it's been pretty, it's not perfect, but it's really taken a lot of the pain and angst over it out, and they adequately fund that through the years.
It seems like the practical reality on the front end, you got to be able to have the ability to do these things, and then you have to be able to respond once the pumping begins. I guess the question from a legal perspective, Russ, that I have is that I called it the M word because you used to not really be able to talk about mitigation because there was a question about whether districts had the authority to require mitigation. Is that legal question put to bed with this statute? Can a district require a permit holder to participate and to contribute to fund mitigation?
You know, I always reserve the right to disagree with myself, so let me just start with that. But, but yes, I believe districts do have the right to require mitigation in connection with large-scale production permits. Again, it's a question of reasonableness. As a practical matter, mitigation can't be applied in such a way that it prevents the actual exercise of the right to produce. But the bottom line solution to large-scale impact of large-scale production is mitigation. And to the extent that the district can manage the impacts through its regulatory program with the assistance of a mitigation program, that addresses the problem in the best way that can be addressed.
All right, so Adam gave me early permission to go a little long, but I don't want to take advantage of you all. So we're going to wrap up here. And I want to finish up with what I call the benevolent dictator question. It's my favorite thing to press the panelists on. But it's this prospect, well, it's got two pieces. You know, what's a practical thing that can be done to address some of the challenges that we've talked about related to these large-scale production permits? And if you had that magic wand, you were the benevolent dictator, what would be the big fix that would really move the needle that could address some of these key challenges? And so, Laura, I'm going to start with you.
Thank you, John. First, I'd like to add more rain to the entire state. So everybody.
More rain. That's a good one.
Everybody
Yeah,
in
that's a
Texas
magic
gets
wand
more
fix.
rain. And then the second part is that I would make desalination more affordable because it really is the future. We've got to be able to afford to desalinate.
Yeah, and as Chairman Perry said yesterday, that's his big push. He feels like that could help take some of the pressure off of rural Texas.
And then I have one more quick one that's just a personal one. I'd also put pockets in all dresses.
Oh, wow. Okay. I have no opinion on that. Thank you, Laura. I also asked this question of a panel about a month ago, and they said, similar to more rain, they said inexhaustible aquifers. I'm like, okay, fair enough. Carlos.
Two things. We need to invest in better modeling and better science, and it needs to be sustainable investment, and it needs to be investment that is led by the state, not just by the local users. You cannot ask the groundwater conservation districts to undertake everything that they are charged to do under 36 and not support them. So that's one thing. We have failed in that. The second one is I would build a time machine, and I would go back to when these court cases were first settled, and I would tell the judges, don't pay attention to English water law. The Spaniards had it right.
See, isn't this fun? We could this one has a time machine in it and dresses with pockets. All right. Steve, you're up.
Well, I appreciate Carlos opening the door to fantasy, so I'll go on there. I do think the reach up to 36 and in the rules there's definitely a really good framework. The question is whether or not it's being implemented by the intent of the legislatures, and I think it would behoove everyone to get the right group of people to figure out how to kind of implement what was intended, and you would start with the science and making sure we're collecting the right type of data and developing the GAMs to do what's needed, which is to protect impacts. In these models, the way they originally developed the GAM program is for a different reason, and now it's a lot of impacts, and you develop a model for its use. And I think we have to look at to see if we're getting the right data and the science is right for predicting impacts. The second is planning, and it's the issue about DFCs. The DFC has a lot of considerations. There's 9 considerations, but the goal of a DFC is to get that balance between the highest practical pumping and conservation, and that's what should be looked at in these explanatory reports if that's being achieved with the considerations. And we tend to focus on, hey, these are the considerations and not whether it's accomplishing that objective. So when the board reviews the explanatory reports, they should have more of a leeway, just making sure whether it's administrative, but is it really accomplishing that objective? And lastly is execution and planning and making sure that we have the right rules and guidelines so river authorities, GCDs, GMAs can integrate and develop the management wisely. You get conjunctive use, you get mitigation maybe going across property boundaries, things of this sort. The aquifers being managed properly as at regional level, not just on county basins. So that's my fantasy world, and see if you can continue with that, Russ.
I love
Russ?
the fantasy world concept, but let me just jump in and say, if I could wave a magic wand and make something happen, it would be to make it abundantly clear in Chapter 36, the districts have the right to impose a mitigation requirement on permits, not just for export permits or large-scale production, but for all production. And the fair way to do that is to apply it to all. So with that said, that would be my fix.
All right. Yeah. Is this being recorded, y'all? Did y'all write that down? Thank you, Russ. I agree. I think that's a great suggestion. Okay, Adam, do we have time for questions?
Yes, we have time for at least one question, maybe two.
Hi.
Charlene, hello.
Thank you. This was such a great panel. I really appreciate this discussion. And the mitigation bill that was discussed is interesting because it seems to open a door, maybe a door that was already open toward groundwater districts, directing their fees toward demand management activities or programs, and even supply augmentation. And I wonder if you all could talk a little bit about the role that GCDs can or should play in facilitating those solutions, whether it's hard capital infrastructure, new supplies, or if it's demand management programs beyond the Water Development Board's ag conservation program that already exists. What's the right role for this particular class of political subdivisions to play in helping us to manage supply and demand beyond permitting and science?
Carlos grabbed the mic real fast.
No, I've been designated to try to answer it. I didn't catch, there's horrible echo in the room.
Yeah, so she was asking about what districts could do to really help to facilitate demand management and also to help with augmentation of development of new supplies. Is that right, Charlene? Did I get that?
We're utilizing the
That's
mitigation
right.
funds.
And specifically through the mitigation bill
Yes.
that was described, looked like it was explicitly contemplating those purposes for funds that districts.
Right, the
Yeah.
statute allows for uses of other things that I did not include.
Right, and that part I got when you asked the question, and I'm glad you raised that issue because it isn't just about making an inoperable well operable again. You can also collect mitigation fees so that you can advance your own science. So that, and I view it, and I'm not a lawyer, so I can view it any way I want, I guess. I view it as investing in monetizing conservation efforts, doing the efforts like what Post Oak has done, where if you want to maintain your water in place, we'll pay you not to produce it. Those things I think are within my read of it. I think that fits.
Yeah, Robert?
So about 15 years ago, I wrote and performed a rap song at a legal conference called "It's All About Dem DFCs."
I was there,
You're
Robert.
there, yeah.
It's burned into my brain.
Rock on. So a MAG is a number that's the best estimate of how much can be pumped to achieve a desired future condition. Districts are required to pass rules, do a number of activities related to DFCs, but pass rules to achieve the DFC. There's a petition process with TCEQ that if districts don't pass rules and aren't enforcing those rules to achieve the DFC, TCEQ has the authority to dissolve the board and to dissolve the district. So it makes me nervous when I hear folks say that MAGs are just a planning number. The mother of the MAG, the DFC, has some pretty hardcore teeth in her mouth. And so, I get that the MAG is a little mushy because the models aren't perfect. even if the models were perfect, we don't know exactly how the pumping's going to be realized. That has an impact on how much you can pump. But ultimately, the MAG is really just a number that reflects how much you can pump to achieve the DFC. So just wonder if you have some comments about that. To me, the MAG is still pretty dang important. You know, yes, it's mushy, but it's not just simply a planning number. It's something that relates to achieving the DFC.
Yeah, I heard it described as a goal, but to Robert's question, should the MAG have more weight?
Should it what?
Should it have more weight?
You know, the bottom line is it would be nice to have more weight, but as a practical matter, it can't be viewed as a limit. It just can't.
But the DFC is a limit.
DFC is a goal.
Is it?
Okay.
I mean, if your district goes away, if you don't achieve it,
This is why we
pretty
love this, because
serious.
I think the room might be cut in half on this one. We're not. Yeah.
Yeah, in the paper we wrote, we have a comment on, you know, if you are absolutely confident that MAG, no matter where it was distributed, pumping, would reach that DFC, then, you know, I could see where the MAG would be really important. But I think we all understand if you pump that same amount in an outcrop versus the same amount down dip, you're going to get a heck of a lot more drawdown than you would up there. So, you know, actually just looking at that total amount and not the distribution is technically not, I can't support that. Knowing what I know about aquifers, but I do know if there was a little more discussion about what a MAG, how it's distributed, I think I would put more teeth into it.
And I don't disagree with that, but I guess I disagree with saying, well, it's just a planning number. When it's a number that reflects a DFC, that if a district doesn't achieve a DFC, it can completely go away. There's a process in law for it to completely go away, which seems pretty regulatory. It's the state saying, yo, you need to, you know, there's a rap coming out. Yo, you need to achieve that DFC, otherwise you could be in deep trouble.
All I heard is you didn't disagree with that. So thank you, Robert.
All the rest was Charlie Brown's teacher. Let's go over here, Linda Kay.
No, out of respect for other speakers, I'd like to move on. So
Okay.
if we could give everybody them a huge round of applause, and I'm sure they will be available outside.